On January 27, 2025, Christy Cohen found herself facing a sweeping list of criminal charges in Greenwood County, Kansas. Prosecutors accused her of driving under the influence, possessing a firearm while intoxicated, operating a vehicle without a court-ordered ignition interlock, driving uninsured, driving on a suspended license, transporting an open container, and even violating window tint laws. All of it traced back to a single traffic stop just after 9:20 p.m. on January 22nd when Deputy Blake Pfizer pulled her over, claiming her window tint appeared illegal. What followed quickly became a legal fight over the very foundation of the case. On June 16th, Ms. Cohen's attorney, George De Hoyos, moved to suppress all evidence, arguing the stop itself lacked reasonable suspicion and therefore poisoned everything that came after. Just days later, on June 24th, the state raised the stakes by filing an amended complaint, upgrading the DUI to a felony based on prior convictions. That same day, Magistrate Judge Phyllis Webster held a suppression hearing and later denied the defense motion. But the amendment changed everything. Because the case was now a felony, Ms. Cohen had the right to relitigate suppression before a district judge with proper jurisdiction. That renewed hearing took place over Zoom on October 16, 2025, before Judge Charles Hart with County Attorney Jill Gillette representing the state. Our footage begins as the state questions Deputy Pfizer, setting the stage for a deeper clash over whether this stop should have happened at all.
Were you able to see into Ms. Cohen's vehicle?
No.
Now, I know we had gone over this before, so when she went in front of you, what, if anything, can you describe to us, did the interior look like?
I can't tell you what the interior looked like. It was too dark.
And if someone has correct window tint, are you able to see how many people are in the vehicle?
Yes.
Are you able to kind of tell what the interior of the vehicle looks like?
Somewhat, yes.
Have you been using this technique for a while?
Yes.
And when you stopped this car, did you eventually test the window tint?
Yes.
What was the window tint reading of the vehicle when you were able to test it?
It was 11% window tint.
What is the legal percent in the state of Kansas?
35%.
Do you explain every time you go through a case, all of your experience or how you use specific testing?
No.
And so is there anywhere in your report you explain how you use your experience and this technique of checking windows?
Not that I believe.
I will pass this witness to the defense.
Cross-examination, Mr. De Hoyos.
Judge, thank you, sir. Deputy Fisher, I want to make sure I understand the way in which you determined the windows were too dark. How long did you have to observe the vehicle that you pull over?
I don't know an approximate time frame. I mean, she was driving by at highway speeds.
Okay, and that highway, that's US 54 or 54-400, is that what that is?
400.
Forgive me, 400. Is 70 there? 75?
65.
65, okay. Middle of the night, right?
Correct.
And you say that the technique you employed was you had you flash your high beams to see if you could see through the windows, is that right?
I don't flash them, I sit with them on.
Okay. So you sit with them on and help me understand what happens after that.
As the vehicle drives by, I make my observations.
Okay. I mean, is this a lawfully approved technique? I mean, is there a sheriff's or a county association or any kind of police association that approves of this technique?
Not that I know of. I mean, it's reasonable suspicion. She drove by, saw that the window tint appeared to be too dark, so I had reasonable suspicion to believe that the window tint was too dark, so I initiated the traffic stop.
So hear me out, Deputy Fisher. I appreciate that. When it comes to the lawful definition of reasonable suspicion, all that, I'm not worried about that. I'm trying to understand the facts. And the fact is you use a technique that has not been supported by any lawful community or law community that you're aware of.
No, we all use it.
As it stands right now, you don't have the experience to be able to say that at a passing glance what percent the window tint is.
I can't tell an exact percentage, no. And I don't think anybody would be able to tell an exact percentage, but I know that if a vehicle is driving by and I can't see into the vehicle, it's reasonable to believe that it is too dark.
Okay, so If somebody drove past you while they're holding a blanket against the window, does that mean their window tint is too dark?
No.
Okay, but that would still create the same effect that you not being able to see through the windows and then pulling them over because the window tint is too dark, even though that wouldn't be true, right?
I would disagree with that.
Okay, which part?
Well, if the window tint was not too dark and they drove by and they were holding a blanket up, I would be able to see that they were holding something up. As she drove by, I wasn't able to see her or any other person in the vehicle, indicating that the window tint itself was too dark.
And are there any outside circumstances that can affect your judgment as to the lightness or darkness of the window tints as they fly by you at 65 miles an hour?
As in,
Oh, I don't. In a storm, would you just make the same call? Would you make the same pullover and same arrest?
I mean, it could alter some, I guess, but no, not really.
So, at the time in which you observed the defendant's vehicle, was it by itself, or was there any other vehicle within its proximity?
It was by itself.
So, if the video of you observing that, I think it was a Chevy Sonic, demonstrates that it was right next to and alongside an 18-wheeler that was all black and that you observed it with the all black background, that would not be consistent with your memory and the way you would do this technique. Is that correct?
I mean, from what I can recall, like I said, I haven't been through the video, I haven't been through the report. From what I can recall, what I saw was her. I wasn't paying attention to any other vehicle. And it was the front passenger side window that I was paying attention to. She was closest to me. We were in a 4-lane highway. She was heading eastbound. She was the closest vehicle to me. So I was looking at that window specifically.
Okay. Well, I appreciate that. I have a body or a dash cam video. So, Your Honor, I'm going to move to admit defendant's exhibit A. This is the dash cam video from Officer Fisher's vehicle that demonstrates what he would have seen as the vehicle the defendant was driving passed by at 65 miles an hour on US 400.
Any objection by the state? Miss Gillette.
No, Your Honor.
The exhibit is admitted into evidence and the court will view the same.
Can you see it okay, Judge?
Yes.
Judge, if I may resume cross-examination.
Yes, please resume cross-examination of the Deputy Fisher.
Just real quick here, Deputy, that's a true and accurate copy of the video that would have been observed from your dash cam that night. Is that right?
Correct.
Okay. And there was at least another vehicle on the roadway, that being the semi that was behind the defendant's vehicle. Is that right?
Yes.
Okay. And do you agree that that's a little different than the testimony that there was another vehicle with it? There was another vehicle with it, right?
Yes. Yes.
Okay. That's all I got for you, Deputy. I appreciate that.
Any redirect, Miss Gillette?
Yes, Your Honor. Deputy, he's asked you lots of questions about what was behind the vehicle, but you said you were concentrated on the front window and inside. Does it matter what's behind the vehicle?
No.
And your testimony was that you're focused on the window. Are you focused on being able to see what's in the vehicle versus behind the vehicle?
Yes.
Now, I kind of alluded to this before. I get to spend a lot more time with deputies and talk to them. I've even done ride-alongs. Based on your experience, can you tell when a vehicle is approaching if it's faster or slower than what should be normally the speed of the vehicle?
Yes.
How can you tell?
Based on my training and experience, I've been doing this for long enough to know that the way the vehicle is oncoming towards me, I can kind of adjust the speed in my head and kind of see how fast it's going, and then I affirm that with my radar.
You said all of us do this test. What do you mean by all of it?
Like deputies and officers in general, we use the same practices.
How often would you say you do this?
Every night that I work.
Judge, I'm going to object to the relevance of these questions. If the strategy is inappropriate from the beginning, it doesn't matter if he does it 1,000 times a day.
Now,
Objection sustained.
I'm getting to my point, Judge, because experience based on the experience and totality of the circumstances is what he needs for only reasonable suspicion. He doesn't have to have probable cause. And he's already said he could reasonably infer that her window tint was too dark. And we're getting to his experience here. Deputy, are you provided with a tool to measure window tint?
I am.
Are you able to use that while a vehicle is in motion?
I am not.
So if you have a reasonable inference that the window tint is too dark, do you effectuate a traffic stop?
I do.
What happens when you effectuate a traffic stop with a reasonable inference that the window's too dark?
After explaining the reason for my stop, I test the window tint.
Can you test it at night?
Yes.
Can you test it during the day?
Yes.
If someone's window tint is legal, what do?
I let them on their way.
If the window tint is too dark, then what do?
I take further action, whether that's issuing them a warning or a citation.
Now, in this case, based on your experience, did you have a reasonable inference that this window tint was too dark?
Yes.
Once you stopped the vehicle, did you conduct the window tint test?
Objection to relevance.
It's relevant if he confirmed that it was too dark.
By that time, we're saying it's already illegal, so it doesn't matter.
Objection sustained.
Mr. D. Hoyos immediately objected during the state's questioning, drawing a sharp line around what actually matters in a suppression hearing. His argument was simple, but decisive. Whatever the window tint measured after the stop is legally irrelevant. The only question the court is allowed to answer is whether Deputy Fisher had reasonable suspicion at the exact moment he initiated the traffic stop. Judge Hart agreed and sustained the objection. That ruling rests on long-standing Supreme Court precedent. In Terry v. Ohio, 1968, the court made clear that reasonable suspicion must be evaluated based on the facts available to an officer at the moment of the seizure, not with the benefit of hindsight. The standard is whether a reasonably cautious officer, given what they knew at that time, would believe the stop was justified. The court reinforced that principle in Florida v. JL's 2000. Their officers acted on an anonymous tip that turned out to be correct. Yet the court still ruled the stop unlawful because the officers lacked reliable, articulable facts before the search occurred. Accuracy after the fact does not cure a constitutional defect. The same logic applies here. Even if Ms. Cohen's window tint later tested illegal, that result cannot retroactively justify the stop. The Fourth Amendment demands reasonable suspicion at the outset, not validation afterward. Under Kansas Statute R. 6401, evidence must be relevant to a material fact at issue. Since the sole issue was whether reasonable suspicion existed when the stop began, Judge Hart correctly barred post-stop tint measurements as irrelevant to the suppression inquiry.
Does any officer or anyone have a test they can do on windows prior to stopping the vehicle if they have a suspicion?
Not that I know of.
Objection to relevance.
Objection sustained.
Judge, it's relevant because if there is
Objection
no,
sustained.
is there any device that you've been provided that can test a window before you have the reasonable suspicion to stop it based on your experience?
I'm going to object to that as for a legal conclusion.
No, it's asking if he has a device.
Well, the request of before you, that's the
Objection
problem.
overruled.
Do you have a device that can test window tint before the stop?
No.
Do you have to stop the vehicle to test the window?
Yes.
In this case, based on the totality of the circumstances, the technique in which you were trained in your experience, did you have a reasonable suspicion her window was too dark?
I did.
Now, once you stopped this vehicle, was there something else that drew your attention onto it more?
The window was rolled partially down.
And did you run the tag on the vehicle?
I did.
Were there any issues with the registered owner?
She had a no bond warrant out of Butler County.
Now, but your initial stop was based on the window tint.
Correct.
And which window was rolled partially down?
I'm going to object to relevance.
It's irrelevant because if the driver's side window was rolled partially down or the passenger side window was rolled partially down, if he can't tell that the other window was rolled down until he stops, that's further evidence that he couldn't see into the vehicle because he couldn't see her and he couldn't see into the vehicle.
I'm confused. Are you saying that the window
I'm
was partially?
confused also. What about the rolling down of a window makes it relevant as to the tint percentage darkness to the windows?
I'll withdraw the question. So Deputy, when she drove by, could you clearly see the driver?
No,
Could you see if there was a passenger?
no,
Could you see anything into the vehicle?
no,
Is that normal?
no.
I'll pass the witness.
And Mr. De Hoyos?
The only reason
Recross?
sorry, Judge, the only reason you stopped that vehicle is because the window tint appeared too dark as it passed you at night going 65 miles an hour. Is that right?
Correct.
Okay. You said that based upon your training, you determined it to be too dark. What is the training you've had in identifying window tint being too dark?
Just at work.
What kind of training? Like a national training like you did for your CLEs and for your law enforcement training, or was this something different?
Just my regular field training.
Okay, so in field training, they teach you how to use your eyes to determine tint values in a vehicle.
Correct.
So Kansas Law Enforcement Training Center has classes on how to identify.
Mr. DeHoyo, I just said my field training. That was not my academy training. My
Okay, so-
field training.
Okay. And the field training, who provided you the field training on how to identify how dark windows are?
I was with numerous deputies.
Okay. And are they using a national program, something that's been federally approved, or even
I
approved by
don't
any law
know.
enforcement?
I don't.
Have you ever seen any literature on any of those things?
I've already asked and answered no.
And there's no studies you've seen about how observations could be changed by the direction of travel, the way the light hits anything behind it, nothing like that.
Mr. De Hoyos then shifted the focus directly onto Deputy Fisher's claimed training and experience, zeroing in on the method he used to justify the stop. At night, Fisher testified that he shined his high beams into passing vehicles to see whether he could look inside and assess the window tint. The defense made clear why that mattered. Courts have long held that while officers may draw on their training, reasonable suspicion cannot be built on investigative shortcuts or educated guesswork. In Terry v. Ohio, the Supreme Court drew a firm boundary. A stop cannot rest on an unparticularized suspicion or a mere hunch. To intrude on Fourth Amendment protections, an officer must point to specific, articulable facts and explain how rational inferences from those facts justified the stop. Technique alone is not evidence. By pressing Deputy Fisher on whether this nighttime high beam method was officially sanctioned, supported by empirical studies, or capable of producing reliable observations, Mr. De Hoyos was attacking the foundation of the stop itself. His goal was to show that what the deputy described as experience was, in reality, speculation, and that speculation falls short of the constitutional standard required to seize a driver.
Any objection to the witness, Deputy Fisher, being excused from the proceedings? Ms. Gillette
No, Your Honor.
and Mr. De Hoyos.
No, that's fine, Your Honor.
Further evidence to present? Ms. Gillette.
The state will rest, Your Honor.
And evidence to present? Mr. De Hoyos.
Yeah, between the deputy testifying and the exhibit, that's what we have.
Thank you. Counsel request any argument in regards to the motion?
Please, Your
Ms.
Honor.
Gillette, please
Yes,
proceed.
Your Honor, in a traffic case, in a traffic stop, officers do not have to have probable cause beyond a reasonable doubt. They have to have a reasonable inference. An inference is much, much, much lower. An officer is allowed to use their training and experience in the totality of the circumstances. A traffic stop is a Terry stop. Reasonable suspicion does not have to be probable cause. Doesn't have to be, I know that exact number beyond a reasonable doubt, because there's not a device that can test window tint until you stop the car. The window tint was tested, and Deputy Fisher was absolutely correct. The window tint was dark. Clearly, Deputy Fisher was absolutely right in being able to tell that the window tint was too dark. Under his totality of the circumstances, his experience, and his training under the law.
Argument for the defense. Mr. De Hoyos?
So, Your Honor, the reason I was not prepared to play that video was because I didn't expect the officer's testimony to be different from the facts shown in the video. Specifically, there were other vehicles on the road. There were vehicles in close proximity. And we don't have any kind of science studies or anything else supporting the idea that this is an unreasonable association. I think what this is akin to is bite mark evidence, which was outruled in the 70s and 80s. At the end of the day, Judge, I mean, this is a hunch, a guess, not a truth. This is, let's go see if that's too dark and pray we're right. And the idea that we do this all the time is not a defense. No, there is no science supporting this. We don't have any kind of evidence or science describing how that vehicle being behind it changes that reflect. And what if that vehicle is reflected? What if it's matte surface? We don't know because there's no science that supports the idea that this is reasonable to go about this way. If the officer had waited to initiate the stop until after he read the license plate and came back with a warrant, I might not have an argument here. How can we tell the difference between window tint, just the circumstances of night, or if I'm holding something up, that's not illegal either. I mean, I guess my point here is I want more than a hunch to pull people over, and this doesn't beat that.
Thank you, Mr. De Hoyos. Court has had an opportunity to view the exhibit as presented today. The court has had an opportunity to listen to the testimony of the Deputy Fisher. Subsequently, the court finds the incident occurred well after sunset. There was no moonlight, there were no street lights, and there were other vehicles on the subject highway. The court finds a factual basis has been established, so this court determines the Deputy Fisher could not establish a reasonable inference or suspicion that the window tint exceeded the 35% darkness allowable by law. Therefore, the court does grant the defendant's motion to suppress.
After hearing from both sides, Judge Hart reached a clear conclusion: Deputy Fisher did not have reasonable suspicion to initiate the traffic stop. With that finding, the court granted Ms. Cohen's motion to suppress, a ruling that effectively dismantled the prosecution's case at its foundation. Judge Hart's decision turned on the exclusionary rule, a core safeguard of the Fourth Amendment. Under this doctrine, evidence obtained through an unconstitutional search or seizure is barred from use at trial. In practical terms, once the court determined the stop itself was unlawful, everything that followed Deputy Fisher activating his emergency lights became legally tainted. The Supreme Court made this principle binding on the states in Mapp v. Ohio 1961, holding that evidence directly obtained through a Fourth Amendment violation cannot be used by the prosecution. 2 years later, Wong v. United States 1963 extended that protection even further. The court ruled that not only direct evidence, but also all derivative evidence, statements, observations, and physical items that flow from the illegal act must be excluded as the fruit of the poisonous tree. Applied here, Judge Hart's ruling meant that every piece of evidence gathered during and after the stop was suppressed. Without a lawful basis for the seizure, the state was left without admissible proof to pursue the charges arising from that encounter, underscoring how constitutional limits can decisively shape the outcome of a criminal case.
Honor, the state asked the court to reconsider because you're ignoring the officer's training and experience that allows him in the totality of the circumstances and utilizing methodologies that are used commonly in law enforcement. Common methodologies are recognized. So we would ask the court to reconsider and deny this motion to suppress, the same as Judge Webster did, based on the totality of the circumstances and the training and experience of law enforcement officers, because they have a lot more experience out there in recognizing these things in split seconds than the normal layperson, which has been routinely recognized by the Supreme Court and the appellate courts, and we'd ask the court to reconsider.
As District Judge of Division 2 of the 13th Judicial District, the court overrules the state's motion to reconsider.
The state requests a stay on dismissal for a notice of appeal.
Any objection Mr. De Hoyos.
No, I believe the state is entitled to an interlocutory appeal under the circumstances.
And the court grants the stay pursuant to the motion of the state here.
This is the point where the courtroom stops arguing facts and starts defending the Constitution itself. After Judge Hart granted the motion to suppress, the prosecution reacted immediately, not with new evidence, not with new testimony, but with pressure. Miss Gillette asked the court to reconsider, essentially asking the judge to undo his own ruling. A motion for reconsideration isn't a second bite at the apple. It doesn't reopen the record or allow the state to patch holes in its case. It's a narrow request, meant only for situations where a judge clearly overlooked controlling law or misunderstood an argument. Judge Hart didn't waver. He denied the request and stood by his original conclusion the evidence was obtained improperly and it would not be used. That should have been the end of it. But instead of accepting the ruling, the prosecution escalated. Ms. Gillette then asked for a stay, a pause, so she could pursue an interlocutory appeal. This kind of appeal is rare for a reason. It allows the state to challenge a ruling before a case is finished, but only when that ruling is so devastating that the prosecution cannot realistically proceed without it. And that's exactly what this moment exposed. The state wasn't appealing because the ruling was minor. It was appealing because without the suppressed evidence, the case collapsed. By granting the stay, Judge Hart froze the proceedings exactly where they stood. Nothing moved forward. No dismissal, no trial. Just a legal time out so a higher court could decide whether the suppression order was correct. On November 3rd, 2025, the notice of interlocutory appeal was filed. As of now, the case remains unresolved, suspended in constitutional limbo. And that pause tells us something important. This hearing wasn't about paperwork or procedural gamesmanship. It was about the Fourth Amendment, specifically the requirement that police action be grounded in reasonable suspicion. Reasonable suspicion is often treated like a technicality. It isn't. It's the line between law enforcement and guesswork, between objective facts and instinct, between constitutional policing and fishing expeditions. When that standard isn't met, courts aren't being lenient by intervening. They're doing their job. That's why the exclusionary rule exists. Not to help criminals, as critics often claim, but to prevent the government from benefiting from unconstitutional conduct. Evidence obtained unlawfully isn't unreliable by accident. It's excluded on purpose. Judge Hart's ruling reflects that obligation. And the prosecution's immediate appeal highlights just how powerful suppression decisions really are. Strip away unlawfully obtained evidence, and even serious charges can evaporate. Now, the final word moves to the appellate courts. They will decide whether the stop that triggered everything met the minimum constitutional threshold, or whether it failed at the very first step. Until then, this case stands as a reminder that constitutional violations aren't abstract. They have real consequences. They stop cases, they end prosecutions, and they force courts to confront whether law enforcement followed the rules it's bound by. The Constitution doesn't bend for convenience. And when courts enforce it, the system is tested, exactly as it was designed to be. If there's another case or courtroom moment you want to break down next, send it over.